Another developing story we're tracking for you: state marriage officers and magistrates whose religious beliefs conflict with officiating same-sex marriages may soon find themselves solemnizing gay marriages. Now, this is after the National Council of Provinces removed the objection clause from the Civil Union Amendment Bill. Now, Freedom of Religion South Africa made submissions on alternative solutions which would require anyone to violate their conscience, saying the bill was unconstitutional. Now, for more on the story, let's unpack it for you. We're joined via Zoom by Michael Swain, who is Director of Freedom of Religion South Africa. Thanks very much, Michael. Good morning. Thanks for your time on the AM report. Give us your analysis, your view of this development in the Civil Union Amendment Bill.
Well, it's obviously very unfortunate because, in a very real sense, the passing of this bill will go directly in conflict and contradictory to what the Constitutional Court has already ruled on this matter. In a case called Fourie, which led to the drafting and the passing of the Civil Union Act, Justice Sachs specifically said, and I'm going to quote him, that the principle of reasonable accommodation could be applied by the state to ensure that civil marriage officers with sincere religious objections to officiating at same-sex marriages would not themselves be obliged to do so if this resulted in a violation of their conscience. And so I think right off the bat, it's very concerning that this bill has gone through, because effectively it is, which is never supposed to be, a kind of winner-takes-all situation. And there was a mention of a sort of celebratory sense in the LGBT community. But the problem is that we live in a country that is supposed to celebrate our diversity, not to impose one particular view on another. We're supposed to be accommodating. And in this instance, if you have a sincere religious belief as a state marriage officer, and you're still an individual with individual rights, then you will potentially now be forced to do something which violates your conscience. And that really is something which should never happen, and which the Constitutional Court has already said should not happen.
So, Michael, this is an interesting point that you bring up. So this is what the Constitutional Court has already ruled, and in many ways, correct me or disagree with me if I'm wrong, or if you think I'm wrong, in many ways, what the Constitutional Court is saying doesn't give that freedom of religion, that freedom of being, to those in the LGBTIQ plus community to get married, to celebrate their love in that way. So on the one hand, what the Con Court has decided, according to what you've just told us, it protects that one section of the population, those people whose religious beliefs are in conflict with same-sex marriages, but it doesn't protect those who want to cement their love before God.
No, it absolutely protects those who want to cement their love before God. That was what the whole Fourie case was about. And as a consequence of that case, the Civil Union Act was then duly drafted and passed. So there is nothing which today even would stop anybody who is of the same-sex orientation from celebrating their love, from being married. That clause was specifically put in so that people who perhaps with sincere objections to solemnizing such a union would not be forced to do so. And that was why it was originally put into the Civil Union Act. The Civil Union Act was drafted as a consequence of the Constitutional Court judgment. It did accommodate initially what Justice Sachs had said that it should, and now that is being removed. So what we're seeing is really literally a winner-takes-all situation, where those people who work for the state and even magistrates will now potentially be obliged to solemnize something, even if it deeply violates their own conscience. And that is the big challenge. It is, do you obey God or do you obey man? And in this instance, of course, if you decide that you want to obey your conscience, then potentially you will lose your job. And that's never a situation that we should have in a free democracy.
So what's the next step here for Freedom of Religion South Africa? Is it something that can be taken on appeal?
Look, everything can be taken on appeal. The question is, will it be? And there are certainly grounds for it to be so, because, as I said, the Constitutional Court has already made a ruling on this matter, and for whatever reason, Parliament has decided to go contrary to that ruling. And again, this is something which the state should have sorted out. It's a practical issue. The issue is that in certain rural areas, there were not sufficient marriage officers to solemnize. But that's a practical issue. The department could easily have allocated a roving marriage officer, or it could have easily made selective appointments in those areas for those people who would be willing to solemnize same-sex weddings. So there were practical solutions, and instead we've been left with an ideological victory, quote unquote, which we think in a democracy and in a constitutional democracy we're supposed to celebrate diversity, is a very poor outcome.
Michael, is this a principal decision from Parliament? Is it a matter of principle? Because, I mean, surely no one would want someone officiating their union who is being forced to do so and who clearly has a belief against doing so. Is it a principal matter that's being decided in Parliament?
Well, you'd like to think that there were principles involved, but as I said, unfortunately, the net outcome is that state marriage officers and ex officio officers, which obviously include magistrates, in the event that they are put in that position, they will literally have to make a choice between do they obey their conscience or do they do what their job tells them they must now do. And so, yes, there are principles involved, but one has, instead of balancing rights, that's the point. Rights are supposed to be balanced. Freedom of religion, conscience and belief is an equality right. Freedom of sexual orientation and gender is an equality right. They're all equal. They have equal status before the law, and therefore that's why there should be reasonable accommodation. That's why there should be a balancing. But in this instance, there is no balancing. It really is, as we said in our press release, a winner-takes-all situation, and that's regrettable and very unfortunate. It's a very bad precedent.
Right, well, thanks very much for weighing in on the issue. Michael Swain joining us live there via our Zoom line. He is Director of Freedom of Religion South Africa. It says that this decision now that those state marriage officers, those magistrates whose religious beliefs conflict with officiating same-sex marriages, they will now have to choose between keeping their jobs or following their conscience. And Freedom of Religion South Africa arguing it is a winner-takes-all decision in Parliament. The winners here, the LGBTIQ+ community.